All right. All persons having business before the office of judges now for the District of Columbia Court of Appeals. Draw near and give your attention. God bless the United States and His honorable court. This honorable court, the session, please be seated and come to order.
Good morning and welcome to the District of Columbia Court of Appeals. We have two cases on our calendar this morning. The first is 22 AA 806, Tenley Town Preservation Association versus the District of Columbia Board of Zoning Adjustment. We have two counsel arguing for the petitioners today. So Mr. Churchill, I believe you're going first, and then Ms. Coelho, you'll come next. And if I'm mispronouncing anyone's name at any point during today's proceedings, please feel free to correct me. Thank you. When you're ready. Oh, and would you let us know how much time you'd like for rebuttal?
3 minutes for rebuttal, please.
Great.
Thank you, Your Honor. May it please the court. The Board of Zoning Adjustment committed 3 errors when it found it would not be objectionable to bring hundreds of students and vehicles into a residential neighborhood already struggling with serious traffic problems. My colleague, Ms. Coelho, will address the board's failure to evaluate the need for incentives to deter the school from causing even greater impacts than as projected. I'll make 2 other points, both premised on a best case scenario in which the school has exactly the impacts it intends. First, the board erred when it failed to address the ANC's traffic concerns with sufficient particularity and contradicted the school's own statement that it would cause adverse impacts on at least 10 local intersections. Second, the board erred by failing to decide the material and disputed issue of whether the school's enrollment was likely to become objectionably high. Beginning with traffic concerns, the board found at JA 337 that the school's TMP would avoid the creation of adverse impacts on the streets in the vicinity of the subject property. It turns out the DC Department of Transportation has a definition of adverse impacts. And this definition includes a intersection's level of service rating going from a passing grade to a failing grade, or alternatively, the delays at an intersection that is already failing increasing by 5% or more.
Can I ask you a question? Because you're using the phrase adverse impact, and the direct legal frame wording is likely to become objectionable. And are you saying any adverse impact without regard to its magnitude constitutes an objectionable condition, or how do you relate the terms you're using to the legal framework?
Thank you, Your Honor. I'm not aware of direct legal authority stating that every adverse impact is an objectionable condition. However, the Advisory Neighborhood Commission, speaking as the voice of the neighborhood, did raise concern that the adverse impacts which the school projected would be objectionable, and the board did not address that.
But DDOT weighed in, right?
Yes, Your Honor.
And the board took that into consideration.
Yes, Your Honor. So the Department of Transportation concurred in the school's projection that it would cause adverse impacts at 10 intersections. The board credited that testimony. And yet the board determined that there would be no adverse impacts at all.
Well, my understanding of DDOT's ultimate conclusion is a little bit different. I mean, it seemed to suggest that the remedial efforts or the mitigation efforts would be sufficient under the circumstances. Am I misreading what DDOT said?
Yeah, and I think the DC Department of Transportation had evaluated from a different perspective than the legal test the board was required to apply. The department's report states that they viewed the proposed development from a perspective of citywide, what effect will this have on the multimodal transportation network? Whereas the board was required to evaluate focused on this neighborhood, will the traffic impacts be objectionable to the neighbors? There's also testimony from the Department of Transportation saying that because they don't have reliable safety data, one of their key focuses is understanding how to actually slow traffic down in order to make things safer for pedestrians. And testimony that they prefer taking an approach not of avoiding objectionable conditions or keeping them from occurring, but of assessing them after the fact and evaluating what mitigation measures might be appropriate at that point. Which we respectfully submit is not a way of avoiding, but rather a way of addressing objectionable conditions after they arise, which everyone already anticipates in advance.
And when you say the BZA concluded there would be no adverse impact, is that their exact terminology, or were they also, my recollection is that sometimes they might have used phrases like that and other times they were focused on the somewhat different term of likely to become objectionable.
So the board's order addresses queuing issues, which are not front and center in our briefing or in this case. But the terminology that it used when it was addressing the ANC's concern about three specific intersections, 7, 9, and 13. Rather than evaluating the likelihood of objectionable traffic at those intersections, the board simply said, a more blanket statement. The school's plan will avoid the creation of adverse impacts.
I mean, is that, what authority do you have that such specificity is required by the BZA if they're evaluating traffic conditions generally, and maybe more specific to the neighborhood? Do they really have to get down to the point of 3 specific intersections?
Your Honor, the statute requires, uses the terms specificity and particularity. This court's interpretation in COP of that statutory language is that the Great Weight Standard it forces an agency to come to grips with the ANC view and to deal with it in detail and without slippage. We submit that when the school's report says there'll be adverse impacts at 10 intersections, the ANC replies, we're particularly concerned about these 3. Please consider them because we couldn't work it out with the school. Making a generalized statement, which is contrary to the school's own predictions, is neither supported by the record nor sufficiently particular to satisfy the Great Weight Standard.
Apologies for keep circling around to this, but I'm still focused on the difference between adverse impact, if any, and something that is likely to become objectionable. So it seems like if adverse impact means any adverse impact, then an 80 or 85% reduction would have been inadequate too. I mean, the theory seems to be, look, there are some of these intersections are already, not functional. And so adding another car is an adverse impact. It's not a huge one, but like any increase in traffic, it's just, there's no capacity here to increase is an aspect of some of the lines of thinking. And is that your position that if, given that some of these, assume that nothing was going to be done and it was just going to be like 1 trip a day that was going to make a bad situation worse, is that an adverse impact that would preclude the granting of the variance? Or do you think there is some magnitude requirement of the adverse impact? And if so, is there, what's your stab at what that might look like?
I do think there has to be a magnitude consideration. We think that the Department of Transportation has a measure of magnitude already built into its definition of adverse impacts. And when we're looking at intersections where the record shows one of the intersections the ANC was concerned about had 34 traffic accidents in a 3-year period. When we're looking at an intersection which is that bad and talking about a 5% or greater increase in problems at that intersection, the board should at least have considered whether that was an objectionable impact.
Sorry, just the objectionable impact that sort of merges. We've been talking about adverse impacts and then objectionable conditions. And if you'll recall, Judge McLeese said, I think objectionable conditions is the legal framework. And I'm just wondering if you can identify, it seems like a term of art. If there's a definition to objectionable condition? What rises to the level? What measure of adverse impact is an objectionable condition?
Your Honor, I think the statutory language looks to the viewpoints of the neighboring community, and the Advisory Neighborhood Commission is the neighborhood's voice to the DC government. Not to say, of course, that they have final say, but I think that the board's role is to put itself into sort of the shoes of a reasonable person in the vantage point of a reasonable neighbor, and consider whether the conditions would be objectionable. I think there's some flexibility in that standard, but we submit it was an issue not adequately considered by the board. If there are no further questions, I'll yield to Ms. Kalal.
Thank you.
Good morning, Your Honors. May it please the court. In addition to the arguments made by Mr. Churchill, I argue that the board failed to give great weight to the ANC's compliance concern, both by failing to explain why consequences were unnecessary in light of the proposed traffic management plan, and two, failing to articulate an effective consequence that would actually serve to hold the River School accountable. Beginning with the need for consequences, the ANC raised this concern based on its experience in the community and its experience throughout the application process. They raised this concern and noted that given their experience with other schools and the River School at its current location, they were concerned about another development coming in that would be of such great size and of such impact on traffic to the community without any sort of monitoring provisions.
Well, there is a monitoring plan as part of the traffic plan, right?
Yes, Your Honor, there is a monitoring plan. That's correct. And I apologize if I misspoke, but there is no compliance measure that couples that monitoring plan. Now, there's a monitoring plan where the school is supposed to do these assessments of the impact on traffic, and they are supposed to report back on those assessments to the Department of Transportation and the ANCE.
Right, so wouldn't consequences come into play at that point, some future time down the road? I mean, why is it the board's role to determine at this stage to assume non-compliance and bake consequences for that assumption into any approval at this stage?
Because it's important at the outset for everybody to understand exactly what consequences there can be. In the absence of the consequences being baked into this traffic management plan, there are no consequences for this school if they fail to comply with the traffic management plan that is in place.
But if the assumption is, and I know that you all disagree with this assumption, but if the assumption is that the plan will sufficiently mitigate the concerns, then that's the proposal, right? I mean, why would you then assume that there would be non-compliance with the plan and then add that into the board's role?
There are specific reasons for the ANC's concern over non-compliance here. The ANC noted not only their experience with other schools, but also with this school at its current location, and also in this current application process with things like the Center for Hearing and the shuttling issue. The shuttling, for example, was an insistence by the ANC from early on in the application process, which they specifically requested a commitment from the school that they would use shuttle buses in order to attempt to reduce the traffic impacts in the community. Now, the school has carefully avoided actually incorporating shuttle buses into the plan as a requirement of their duties. The shuttle to this day.
By that, I thought that there are two questions. One is, do they have to have a shuttle? And the other is the shuttle mandatory for anybody? But focused on the first question,
Sure.
I thought that the BZA's order included a sentence that said, imposed an obligation on the school to comply with the traffic management plan as described in the set of findings of fact, and that one of the findings of fact that was in that framework was there will be a shuttle. So I thought the order itself by its terms imposed a requirement on the school that it provide a shuttle. You don't read the order that way, or?
That was not our reading of the order. Our understanding of the order was that the traffic management plan allowed for shuttling as one of the enhanced strategies that the school could choose to employ later on if they decided it was necessary. It was not a requirement. And if I could direct your attention, the Office of Planning specifically notes that the school anticipated most students will use vehicles and said at JA 182 that the school will consider shuttling only if necessary. Our issue here is who
So
gets
I-
to
just
decide whether it's.
I'm focused on, I guess, page 27 of the BZA's order. And on that, there's a listing of numbers on that page, and number 6 is again, things that they are ordering the intervener to do. And number 6 is to implement a transportation management plan substantially as shown in exhibits 100B in the record, also described in findings of fact 46 through 64. And if you go back, I think it's in the 40s somewhere in higher than 5, where the order says somewhere that I believe that the applicant will have, I'm trying to find it, but the applicant will have will provide a shuttle.
Your Honor, if that's the case and the applicant is responsible to provide a shuttle, then once again, we are concerned about the compliance measures that will ensure that they do provide that shuttle and the enforcement mechanisms in the event that they do not.
Just to clarify, it's page 10 of the BZA's order. I guess it's paragraph 47, sub 11, that says the applicant will provide a shuttle to transport students to the property from one or more offsite locations, at least during the morning drop-off period. I don't know about the back end, but.
Yes, Your Honor. Now, again, even if that is true, that the applicant is responsible for providing this shuttle bus, this concern and the fact that the Board of Zoning Administration did not address these concerns on the record is the reason that they failed to meet the great weight standard.
I'm sorry, which concern now? Not that they won't provide a shuttle, but that they won't make people use it, or?
Yes, Your Honor. For example, the fact that they will not make the people use it. As if you look into the joint appendix testimony, they specifically say that they do not have a specific compliance measure in place for students to force them into using this shuttle.
Here too, there are two different things. One is, did the school commit to requiring as a condition of enrollment that students K through 6, which is I think what was being discussed for use of the shuttle, use the shuttle? So is it kind of mandatory, at least for some students, in the sense that it would be like something that parents would be required to agree to do as part of the enrollment contract? That's one topic. I tend to think that there are at least a couple of places where the school told the board that it was going to do that. I don't see that in their brief, so it's a question for the school, but that's one topic. You're raising a second topic, which is even if there was such a commitment by the school, there's a question of how is the school going to enforce it against the parents? And I guess relatedly, how is the BZA going to enforce it against the school if either the school doesn't try or doesn't succeed in enforcing against the parents? That's but your view is, what's your view? What's your understanding? You think the school has committed or has not committed to making a condition of enrollment contracts for students K through 6 that they use the shuttle?
My understanding from the testimony on the record is that the school did not commit to such a thing. My understanding from the testimony on the record is that the school committed to saying that they would ask the students to use this, but when pressed by the commissioner during the arguments and in the oral testimony, they said that they would not expel students who did not comply and that they were relying on their culture of compliance.
Again, just to be clear, that's sort of combining two things that are a little bit, it doesn't mean by require. One is if there's a sense in which you require, if somebody enters into an agreement with you that requires them to do a thing, there's a sense in which you require them to do it. There's another question, I guess, about what the school would do by way of enforcement. So just to be clear, do you think the school represented to the board that it was going to make as a condition of student enrollment contracts that children K through 6 use the shuttle?
I do not believe that was clear on the record, Your Honor.
Gotcha. And then your second point is whether they did or didn't do that. You think they were squishy on what steps they would take to enforce any such requirement if there were one?
Yes, Your Honor, that's right. and to borrow your honor's word, the word squishy applies to a lot of the representations made by the school. And it's this wariness over their representations that leads to the ANC's concern about the need for compliance measures. Now, this ANC is not the only one who has acknowledged the need for compliance measures on the record. If you look at Joint Appendix, page 123, the school acknowledged that an enforceable plan is necessary. They said that they recognize the importance of creating enforceable operating plans for the campus that would actually address the concerns raised by members of the community, particularly as they relate to traffic. The Department of Transportation also noted how there is uncertainty as to how this plan will play out. And in their oral testimony acknowledged that this plan is unique. It's not the standard plan that the Department of Transportation approves, because normally the plans that they approve require all of the implementation of the traffic mitigation measures to go in prior to the granting of the certificate of occupancy.
Do you think consequences to parents cannot be considered also consequences to the school?
No, Your Honor, because the school is not required to implement those consequences.
Well, again, that goes to Judge McLeese's point, which is a separate question, but assuming there are consequences to parents up to and including expulsion of the student, is that not a consequence to the school itself at some level?
I would disagree with that, Your Honor. I do not think that a consequence to the parent is a proper incentive for the school to follow the
I mean,
the
when
traffic.
schools are losing tuition paying students and also gaining a reputation in the community of kicking students out, that seems to provide some incentive to the school to enforce compliance with the plan, doesn't it?
We would hope that that would provide incentive. However, again, the ANC's concern is that in the schools in the area, they have not seen traffic management plans play out in this way, where the schools actually follow the traffic management plans. And that's why they've raised this concern. Moving on to the efficacy of those concerns, of those consequences, the board did not meet its burden with respect to identifying any consequences for the school itself that would effectively provide an incentive.
What were the consequences that your clients were looking for?
Your Honor, there was no specific consequence that the ANC elucidated, except for their testimony and the joint appendix, where they said perhaps there would be a fine on the record, or a fine, a mandatory fine, if there's certain thresholds that are not met throughout the course of the monitoring plan.
Is the BZA empowered to impose such fines?
Your Honor, the very fact that there is a $75,000 provision wherein the school is required to agree to give $75,000 to the Department of
That's
Transportation.
not a fine though, right? I mean, to impose a fine, right, you'd need to have some sort of due process procedures. You'd need to have some sort of adjudication of failure to adhere to a binding commitment, and then the imposition of the fine and someone would have to set the amount of the fine. I'm just wondering, does the BZA have jurisdiction to do any of that once a project is built?
I think the BZA itself is unable to answer that question. I think the BZA should have the authority to impose consequences on traffic management plans that are not followed if they're going to.
I guess I'm sort of struggling with, I'm asking what your clients were looking for in the way of consequences. You've identified fines and you're not certain whether the BZA has the power to impose the consequences that you're suggesting. And so could we really say that that's an abuse of discretion for the BZA to disregard consequences that nobody knows that they have the power to impose?
Yes, Your Honor. I have two
That's
responses.
where I'm going.
Yes, Your Honor,
Yeah.
I understand. I have two responses. First and foremost, the board did not list that reason as one why they would not provide consequences. And that is a requirement by the Great Weight Standard, that they actually explain their reasoning and why they were unpersuaded by a need for consequences. If an inability to impose consequences is one of their reasons, they needed to state that within their board order. Second of all, fine is one example, but there are other examples within the traffic management plan of ways that this could have, that there could have been established demand provisions. Like, for example, the ANC actually having the power to demand certain mitigation measures are made following the monitoring plan and in those meetings. The management plan only says that they are required to meet with the ANC. I will note other schools in the district have not met those requirements.
I mean,
in
how
the
could the
past.
BZA empower an ANC to enforce against a private party anything under the zoning provisions that are set forth in the plan? I mean, you really think the BZA could have empowered the ANC to do that in its order?
I think if, given the ANC's concern over compliance mechanisms and the board's insistence that their findings were based on the effectiveness of this traffic management plan, there was a need to figure out how they could ensure this traffic management plan. was
Right,
followed.
but I mean, to Judge Easterly's question, you haven't proposed, you didn't propose, and I don't know if you're able now to propose any concrete consequences that the BZA could have imposed ex ante.
Yes, Your Honor. First, I would
Can I
draw.
ask you, I thought your opponent argued in, I know the board didn't specifically address these alternatives, but your opponent asserts that the board does have authority both to impose fines and also that the district, I don't know if the zoning administrator, I guess, might have the authority to impose a fine, and that the district itself can enjoin unlawful uses of land. I'm referring to footnote 12 of your opponent's brief.
Yes.
Do you agree that those were options that the board could have considered and in your view didn't adequately address or identify?
Yes, Your Honor, these are examples of the kinds of consequences that could have been in place. And exactly as you point out, the school does an analysis of the effectiveness of potential consequences that if the board had done, maybe would have met their requirement to give great weight to the ANC's
But
concern.
if those are pre-existing regulatory mechanisms to enforce zoning violations or to address zoning violations, does the board really have to tick through them in every order that it issues? I mean, those are legally established enforcement mechanisms, consequences.
Yes, Your Honor, the great weight requires that the board explain the reasoning why it is unpersuaded by a concern raised by the ANC. In this case, where the ANC raised a concern over enforcement, the board was required to explain exactly what enforcement mechanisms were available, why they would be effective, and or if neither of those things could be found, why they were unnecessary given the traffic management plan, and they did not do so.
In your view, if the board had added a sentence to its order here, which said there's been a concern raised about what approach the school will take with the parents to enforce the parents' obligations that might be entered into in enrollment contracts or, with other requirements that the school was trying to impose on parents and students. And also the extent to which the board or DDOT or other government entities might secure compliance with the requirements that, if they were otherwise met, would be sufficient to avoid prevent the variance from resulting in, like on the term now, objectionable conditions.
Yes,
Thank you.
Your Honor.
Our answer is that we have authority, statutory authority, regulatory authority under a regulation and a statute. So if it is brought to our attention that there are violations of the commitments that are made here that are resulting in such impact, such consequences or conditions, we'll respond accordingly. C, regulation that authorizes the zoning administrator to impose fines, and C also, again, I don't think the zoning commission itself could. The zoning commission is the BZA is maybe different from the zoning administrator, so it can't make promises on behalf of it. It certainly can't make promises on behalf of what OAG would do by way of enforcement actions to enjoin things. But if it said we have these remedies where we have no reason to doubt they'll be effective, would you think that would have been enough, or do you think that more would have been needed?
Your Honor, I think in conjunction with an analysis as to whether or not those consequences were necessary, that might have met the standard that great weight requires. I think both of those things were entirely absent from the board's order, and that is why they have failed to meet the great weight requirement here.
Thank you, Ms. Coelho. We're going to let you sit down now and we'll hear from Mr. Antwi.
Good morning, and may it please the court. Joel Antwi on behalf of the intervener, the River School. The intervener has conferred with the respondent, the District of Columbia Board of Zoning Adjustment, and we've confirmed that the district does not intend to present oral argument, so I will presume I have the full 15 minutes. As you know from the briefing, the River School is a private school founded to provide an inclusive educational experience for young children with hearing loss. It currently plans to relocate its campus from MacArthur Boulevard here in Washington, D.C. to 4200 Nebraska Avenue. At that location, it'll operate a school serving approximately 350 students, 18% of which have hearing loss.
Mr. Antwi, we're familiar with the facts and 15 minutes can go fast. So maybe we can just jump right into some of the points that we were discussing with your friends on the other side. As far as the shuttle service, do you understand that to be a condition of, or do you understand there to have been a commitment to make that a condition of the enrollment contract?
So, Your Honor, I think that the board's order anticipates that the school will certainly provide a shuttle, and the school committed to reducing pickups and drop-offs by 45%. The shuttle will be a tool.
So there's a gap there, right?
Oh, excuse me, Your Honor?
My question is, has the school committed to making use of the shuttle a condition of the enrollment contract?
I believe, Your Honor, that the answer to that is yes. But
can you point me somewhere in the record where that commitment is made?
I believe, Your Honor, it's in some of the testimony. However, that commitment, as far as I know, does not appear in the BZA's order specifically. And so I think that in the BZA's order, what is anticipated is that the school will provide that shuttle bus.
When you say anticipated, do you agree that it's not just anticipated, it is the BZA order requires that the school provide a shuttle bus?
I do agree with that, Your Honor.
Okay, I just was a little unsure about the word.
Yes, I apologize, Your Honor. Yes, I do agree with that statement.
And so your opponent's argument about the shuttle in the brief in this court is the traffic study that was done. It was very explicit that when it's calculating the traffic that will be generated by the proposed variance, that it is assuming that there will be 0 trips for children who are K through 6 because all of them will be using the shuttle. Do you agree that the traffic study says that?
I do not agree that the traffic study says that. I think that the traffic study So I would say, Your Honor, there are 2 points that I would make about the traffic study. The more important one.
Well, leave aside what points you'd like to make
Yes.
about the answer to the question. I just want to make sure your answer is you don't think the traffic study attributed 0 trips to children who are K through 6.
I do not believe, Your Honor, that the traffic study, or at least the final one, had said that.
Well, there are 3 things. There's the traffic study and then the 2 traffic management plans.
Yes.
So I'm focused now on the study that generated the numbers that the traffic management plan were then intended to address.
Oh, so would that be the CTR, Your Honor?
Yeah.
Okay.
Yes.
Yes.
Yeah, so when the CTR generates the numbers that are then the traffic management plan and the amended traffic management plan are intended to address.
Yes, Your Honor.
Say 0 trips attributable to children who are K through 6.
I do not recall that specifically in the CTR. However, I'm happy to discuss it if you have a different understanding.
Well, I'm not sure I have a different understanding because you're saying you don't have one. So I guess in that sense it's different. But I assume for a moment that that's what the traffic study says.
Yes, Your
And
Honor.
your opponent's argument in their brief is the traffic study says that.
Mhm.
And this is paraphrasing, but the gist of their argument in their brief is, well, first they had an argument about whether shuttle is required at all or not.
Yes, Your Honor.
But you're agreeing that in fact the shuttle is required. Now, the question of whether the students will be required to use the shuttle is a second order question. But their argument is, an aspect of their argument seems to be paraphrased, that even if a shuttle is required, it's not sensible or realistic to assume that everyone, if it's not required that people use a shuttle, it's not reasonable to assume that there will be 100% use of the shuttle by children who are K through 6. I didn't see a response to that argument in your brief, and I didn't really see a response to that point in anything in the order of the BZA. So I wonder if you could help me in understanding what's wrong with their argument. If the steps of it are, all of these numbers are predicated on zeroing out the number of trips for children who are K through 6. And if there's no requirement that children who are K through 6 use the shuttle, that's not a sensible basis for the rest of the numbers to be built on. What's wrong with that argument? Because maybe you responded to it somewhere in your brief and I didn't see it, or maybe you don't think that argument was made by your opponent, but I'm a little unsure about all that.
Well, sure, Your Honor. I think that where that argument fails is that it doesn't at all account for the commitment that the school has made to reduce pickups and drop-offs by 45% across the board.
But those are all predicated on numbers that are, as their starting point, say 0 for any trips K through 6. So the commitment to reduce it from a number that is based on a false premise seems like it's problematic. So I'm not quite sure how that addresses the point they're making.
Okay, so then, Your Honor, what I would say, taking your representation that that we are zeroing out the pickups and drop-offs except for by the shuttle for kids ages K through 6. Then I
don't know that I'm in a position to make representations. I'm just going to tell you what my impression is, but I'm looking at page 38 of the Comprehensive Transportation Review. It's got table 9B and it's got all the numbers that are then the predicate for the two plans. And it says, quote, assumes all students, this is like the second line under where it says table 9B, assumes all students in K through 6 are shuttled from an offsite location in the morning. Mm-hmm. So that's why I have the concern that I'm raising.
Yes, I understand, Your Honor. And so in terms of those, in terms of that projection, what I can, the best answer that I can give you that hopefully works is to say that that the school has, I think in terms of reducing the traffic volume, there's multiple mechanisms to do that. And I think what you're pointing to in the CTR in ensuring that all kids ages K through 6 take the shuttle is one mechanism to do that. And I think that is what the CTR discusses. With that said, there are still a variety of other mechanisms as well that the school can employ.
What was the board's assumption in issuing its order? If it relied on the traffic plan, which in turn relied on the assumption that all students K through 6 would be taking the shuttle, then the board's order rests on a faulty premise. Is that right? If you're now acknowledging that you can't guarantee that all the kids K through 6 will take the shuttle.
No, Your Honor. So I think that the board's order anticipates and does in fact mandate that the school offer the shuttle, use the shuttle, and that the school achieve the reductions in pickups and drop-offs that it has committed to. So
those pickups and drop-off, the reduction is measured against a number that already assumes that there are going to be no trips for children K through 6. So what they have to so I mean, I guess if you were saying the total number of trips has to be what is assumed, that'd be a little different than achieving the reduction from the number that was already presupposed. But can I ask you, I just want to make sure I also get us, you agree that the board's order, although you argue that the board's order, you acknowledge the board's order requires the school to provide a shuttle. you
Yes.
also acknowledge that the board's order does not by its terms require the school to require the use of a shuttle.
That's right.
But
Yes.
you do say that your impression was that in the testimony, the school represented to the board that it would make use of the shuttle mandatory. And I that was my impression too from the testimony. I'm particularly talking about, I guess, page 427 of the joint appendix, where there's discussion and I believe the attorney for the board, for the intervener, Ms. Mellon, says the commitment was that children K through 6 would be provided with a shuttle bus. One of the members of the BZA says, well, what if people don't want to use it? And Ms. Mellon says, well, it's a requirement. It will be a requirement. It's a requirement for each student. Over onto the next page. And whether repercussions is what the BZA member says, and the attorney says, well, then it's a condition of their enrollment.
Yeah.
And so leave aside other issues. I don't know if this would solve the problem, but on the hypothesis that it might, is it correct or incorrect that you would have no trouble with an opinion from this court that said, although the board didn't expressly require this, the logic of the board's order rests on it and the school promised to do it. And therefore, our opinion rests on the idea that there's a legal requirement for the school to make as a condition of enrollment contracts that children K through 6 use the shuttle bus. Again, assuming there's that's a little overbroad because children of faculty probably wouldn't have to and the like, but would you be comfortable with an opinion from this court that noted the school's representation to the board that it would do it and explained that the opinion of the board makes no sense unless that is mandatory? You could debate whether it makes sense even if it is mandatory, because your opponent is arguing that just putting in an enrollment contract that people are supposed to do a thing doesn't necessarily guarantee that they will do it. But that's leave aside my little editorial addition. My direct question to you is, do you have any objection if this were otherwise thought to solve the problems in the case to an opinion from this court that said, based on the acknowledgement of the River School, we understand the River School to be required under this order to make use of the shuttle bus through children's K through 6 a condition of enrollment, a mandatory condition of enrollment.
Yes, Your Honor. So I think that would be consistent with the record. And I'm glad we're sort of getting to the same page here. So what
I just want to make sure yes is a little. My question was unclear enough that I want to make sure I understand what you mean by yes. You mean you would have no objection to something that took away from all of this and expressly said that the school has a legally binding commitment in connection with the BZA's order to make use of the shuttle bus by children who are K through 6 mandatory.
I think that's right, Your Honor.
You would have no problem with that.
I think that's right.
Okay, so now coming full circle to your colleagues on the other side's point, what would be the consequences if that was not adhered to?
Right. Yes, Your Honor. So with the topic of consequences.
Well, I mean, sorry, I just want to limit it to that particular point at this point. I mean, what's to say that the River School will do that and that students will actually comply?
Yes, Your Honor. So I would break that up into two pieces of a response. The first would be that the BZA's order lays out a series of consequences on families that do not comply with the requirements of the transportation demand management plan in this case. Those are laid out in the board's order, and they include consequences up to being dismissed from school. In terms of the consequences on the school for not complying, I think that those consequences are laid out in the board's order as well. And they include, for example, the financial cost of improving infrastructure around it. Presumably, if there were non-compliance with that sort of requirement, that would have an impact on the surrounding roadway network. If that were to happen, the school would have to fund improvements to the roadway network. In addition to that, there are other consequences that the school has to undertake by way of internal mitigation measures. So things like further reducing the number of pickups and drop-offs, as well as converting different areas of the school for additional parking.
So is it your understanding that if our opinion says that it's our understanding that use of the shuttle will be a mandatory condition of enrollment and either the River School does not end up including that in its enrollment contracts, or students sign those enrollment contracts and end up not using the shuttle, that the consequences that you just outlined would all be subject to imposition?
I think that's right. I think that's right, Your Honor. I mean, those are the consequences that the board had laid out. And I think that to the extent that we would be presuming that mandatory use of the shuttle was a part of the transportation demand management plan, and like I said, I think that's a fair interpretation, then violation of that plan would lead to the consequences that I just named and that the board put in its order.
I'm sorry, I'm still struggling a little bit to understand what the consequences are. If a family doesn't use the shuttle, or many families don't use the shuttle, and then the school does not enforce the consequences that are laid out in the BZA order, what are the consequences on the school? You're saying that the school would then be subject to paying for more infrastructure modifications in the neighborhood?
I think it could, Your Honor. So what I mean by that is if the school were to fail to adhere to the traffic demand management plan, and it's required to conduct yearly monitoring, and its failure to adhere to that plan is in fact impacting the surrounding roadway network, it's slowing down intersections, those sorts of things, then I think it is correct to say that the consequences that are laid out in the order, such as funding these additional mitigations on the surrounding roadway network, would come into play.
I assume you also would have no problem with an opinion of this court, and leave aside whether it would be adequate to address petitioner's concerns, but an opinion of this court that said, consistent with the assertions in your brief, that of course there are other governmental entities that would have other possible remedies, including imposition of fines and the issuance of injunctions if the property is being used unlawfully.
That's correct, Your Honor. We conceded in our brief, and actually I believe it was a point that the petitioners made as well, that the District of Columbia has very substantial powers to impose consequences here, in up to and including revocation of the certificate of occupancy, which, according to petitioners, was so great a consequence that it shouldn't be considered here. But of course, it is there, and it is a looming threat for any violation here.
Can I ask you, I'm wrapping back around to what seems to me like a difficulty in the case, which is, again, the concern that there's an assumption that there'll be no trips relating to children K through 6 that's built into all the rest of the analysis. And the board's order, taking as a given for a moment that it requires a shuttle, doesn't require mandatory use of a shuttle, and therefore makes that assumption pretty implausible. We discussed the hypothetical possibility of sort of jury rigging a solution to that problem by this court saying, look, the combination, there's a representation to the board, and the logic of the board's order is such that that would be a requirement. But I guess I'm a little unsure about that. And I mean, generally, I think the board is probably better at writing orders about exactly what's required than we're going to be. And I start getting tangled up with, like, what would the wording of that be with respect to things like, well, is it really accurate to say that all children K through 6 have to use the shuttle? What if they have older siblings? What if they have their children of faculty members, and therefore they wouldn't be generating independent trips? And so it starts sounding like it's something less. It's less a problem that there's a easy judicial fix to, and more a problem that might require further assessment by the board. What's your reaction to that concern?
So I think, Your Honor, the board did so a couple of things. The first is that in circumstances like you point out, where there might be other considerations, I think that The traffic study that was done here is of course, as any study is, a best estimate based on expert opinion. And I think that it encompasses I think the record illustrates that it encompasses probably the best estimate as to how the traffic conditions will play out. There's not, I don't think I don't think that the record would support that a remand is going to necessarily dramatically change any of these traffic numbers. Like I said, I think that the board has committed to the use of the shuttle, or I'm sorry, not the board. The school has committed to the use of the shuttle. And the board has already ordered the use of that shuttle. The only purpose in a remand would be essentially to rerun traffic numbers, which I don't think changes anything in light of the commitments that the school has already made.
I guess I'm not quite following, right? So the traffic numbers are based on 100% use of the shuttle, but for sure there are going to be circumstances where a child who has a parent who's a faculty member, or a child, right? The school only goes through 6th grade, right? But this commitment is for K through 6. And the school offers pre-K. So a child who is in pre-K who has an older sibling would not be required to use the shuttle, but the sibling would, would the parent really have to put one kid on the shuttle and then, drive the younger sibling to school, and so we're talking about enforcing use of the shuttle. And so I think, Judge McLeese's questions have some force for me about how we would come back in and sort of clarify what you're suggesting was the underlying premise of the board's order. So can you try one more time to explain to me why we should be okay with this?
Well, Your Honor, so in the scenario that you mentioned, I don't think that scenario changes the traffic numbers.
That's just one scenario, but I think what we're talking about, what the desire is, right, is 100% compliance. So you want a culture of shuttle use, but you can only have a culture of shuttle use if it's made very clear to the parent community. I might speak from experience here. What is expected of them as far as transportation when they bring their children to school, or when their children get to school, how their children get to school, how their children leave school. And so these details are important to build that culture.
So, Your Honor, I think that the answer to that is that we read the board's order to mandate a shuttle. And to also,
I mean, it sounds preposterous that the school would pay for a shuttle. Shuttles are not costless, right? Shuttles are actually quite expensive. It's something that schools debate about whether or not to pay for, and who pays for it, and how much the parents pay for it, right? So it sounds preposterous that you would have a shuttle that would be entirely empty, but it is theoretically possible that the school could have a shuttle that goes back and forth between a set point to school that would have 0 or 1 or 2 students on it, because the school has committed to use a shuttle, but the school has not anywhere in the board's order been required to make students use the shuttle.
So, Your Honor, and I apologize, this is why I keep coming back to the pickup and drop off number. And that is, since the school has committed to reducing those pickups and drop offs by a certain amount, and yearly monitoring requires it to do that.
So
it is,
you're talking about the 40 to 50% pickup and drop off, right?
Right.
Okay, so are you saying that because that number has been, you've reduced it by 40 to 50%, that necessarily will force people to use the shuttle? Is that the argument?
so I'm saying that the shuttle will have to be a component of that reduction
Well,
strategy.
have to be- okay, I mean, maybe you could follow that train of logic, but it seems like a reduction of 40 to 50% doesn't get you to the almost 100% compliance. Maybe I'm getting my number. I'm not a math person.
Sure,
That's why
yeah.
I became a judge.
I,
So, right,
That's
but I'm struggling between the 100% and the 40 to 50% reduction.
yes, Your Honor. So I think that the 40 to, so this is a couple of things. Number one, in terms of the ages of the students here, in the context of pickups and drop-offs, not all ages are created equal, right? I mean, the very young children would not be able to be shuttled, especially when we're talking about 2 and 3-year-olds. And so I think that the 45% reduction in pickups and drop-offs, that is going to certainly disproportionately come out of the crop of students that are ages K through 6 because they can be shuttled. But there's, of course, going to be another crop of students as well as, the children that are going to the childcare center that are not going to be able to be.
But so are you saying that
So-
if you achieve the 45% reduction in pickups and drop-offs without 100% use of the shuttle by K through 6, that that would be okay under the BZA's order, and B, well, I should have put those in the opposite order. That would be possible. So let me say this again, that you think you can achieve a 45% reduction in pickups and drop-offs without 100% use of the shuttle by K through 6. And B, that would be permissible under the board's order and board's understanding from the testimony.
So the answer to that is, Your Honor, number one, to your first question, I don't know whether or not that's possible to do, to achieve that reduction without the shuttle.
Well, not without the shuttle, but without 100% of use of the shuttle by K through 6, because that was the presumption, I think.
Yes, so whether or not it's possible to achieve that reduction without 100% use of the shuttle by K through 6, I don't know. Would it be permissible under the board's order for the school to reduce its pickups and drop-offs by 45% without 100% use of the shuttle? I think, or I'm sorry, not under the board's order, but under the testimony you asked provided to the board.
All of it together.
I think that under the testimony provided to the board, 100% use of the shuttle was the representation made. With that said, I think that ultimately, though, the question of harm is going to come down to the yearly monitoring assessments that are done in combination with the ANC. There are also quarterly meetings scheduled with the ANC. And so I think the big question here is whether or not that 45% is number one achieved, which we think based on the plan it will be. And number two, if not, or if there are any ongoing issues, what are the mitigation measures that are going to be put in place, which are spelled out in the board's order?
So I guess your point is if you put in you have the shuttle, you put it in the enrollment contracts, you shoot for 100% use by K through 6, and it's not working out, but otherwise you have achieved this 45% reduction in pickups and drop-offs, that everyone should be happy.
Well, I think, Your Honor, I would add something to that.
You might not be talking about happiness.
Yeah, that's true. That's true. But I would add something to that. And what I would say that is that under the yearly monitoring assessments done with the ANC, that and also and I believe there are yearly reports to DDOT as well, that we are not seeing adverse impacts to the intersections that are around the school.
Thank you, Mr. Antwi. We've kept you up at the podium for quite some time. We'll let you sit down now. Thank you for your argument, and we'll hear again from Mr. Churchill.
Thank you, Your Honor. If I may make 3 points on the shuttle issue. First, respectfully, in our read of the board's order, it does not strictly require the shuttle service to be used. if you look at paragraph 47 of the order, that's at JA 323, page 8 of the order. The order states that the applicant's general strategies for the TDM plan are the following. And then when you flip over to JA 325, one of the general strategies in the plan is that they could provide a shuttle. If you
When you say could,
if
that seems like it's your term. What the subpart 11 of that is the applicant will provide a shuttle. So why do you say could?
so the statement that the applicant will provide a shuttle is it's a hypothetical statement about what the school can do. If you refer to the
I can sort of get your, consider it in isolation, it doesn't sound like that. It's like the applicant will do X. It seems like a promise or representation or a statement of future intent or a prediction of the future. It doesn't sound very hypothetical. But I think I take a part of your point, which is if you shouldn't read that in isolation, and you should read it in light of the language in paragraph 47 that precedes it. And that says the general strategies are the following. And I took you to be maybe implying that by referring to it as a general strategy, and then maybe putting it in context of the wording of the latter provision, the final provision that we had been discussing with your opponent, there's a little bit of wiggle room. I can sort of see the light of that, but I'm not quite sure why you're using the word could or the word hypothetical. So
Thank you
I'm
for
not quite with you
clarifying,
on
Your
that.
Honor. I appreciate the opportunity to clarify that. I think part of the context in which we're reading is also the TDM plan itself, which the board essentially incorporates by reference. On JA 69, page 40 of the TDM, the school says the TDM plan is intended to be flexible in order to respond to changes in demographics, technology, et cetera.
Yeah, I'm
And-
still coming back to that. I mean, maybe all of that precedes is flexible and a little more mushy, but the language of paragraph 11 seems pretty specific and pretty directive. Applicant will provide a shuttle. It seems as directive as on the previous page where it says applicant will hold quarterly meetings with the ANC, right? So, I mean, they've got a lot of applicant will. Seems like they're obligated to provide a shuttle. Whether or not they're obligated to make people use it, downstream question, but at least as far as whether or not they're required to spend the money to have a shuttle, have a driver, pay for fuel. Seems like they're required to do that under this order.
Reading the opinion in the context of the TDM statement that this is one of the items in their toolbox, we had not understood the order that way, but I take your point, Your Honor, and that would then I think maybe bring us into the second issue which you flagged, which is the enforcement and the workability of this 100% shuttle usage metric that the board relied on. Respectfully, we don't think the enhanced traffic management measures that the school has referred to are consequences to the school per se. They include things like requiring more students to carpool, which we don't believe will get the number of rides down to zero and does not cost the school anything.
Well, I guess, so the question, I know that you disagree with the 45% reduction and you had the ANC asked for a 70-80% reduction. Putting that aside, if the school were to achieve a 45% reduction in pickups and drop-offs without, with maybe partial use of the shuttle and in combination with other efforts, greater numbers of students have to ride in a carpool, maybe staggered pickup and drop-off times, I don't know. Again, putting aside that you would prefer a 70-80% reduction, would that be compliant with the board's order as you read it?
It would be compliant with the board's order as we read it. As you've noted, we believe that the board's order does not grapple with the traffic impacts that everyone acknowledged would happen. It simply stated that they would not occur. And so if nothing else, for that reason alone, we would request remand so that the traffic numbers even as projected by the school, could be considered with the specificity that is required of the board. If there are no further questions,
Thank you, counsel.
thank you, Your Honors.
Thank you, Mr. Churchill and Ms. Guello. Thanks again, Mr. Antwi. This case will be submitted. Our second case on the calendar this morning is 21 AA 772 DC Department of Corrections et al. Versus DC Department of Employment Services. Good morning, counsel. If you could introduce yourself for the record and let us know how much time you'd like for rebuttal.
Of course, may it please the court, Alex Famelli for petitioners, the Department of Corrections and ORM. I'd like to reserve 3 minutes. What we refer to in our brief as double compensation is doubly banned by section 2316. Each subsection bans it under a different theory. Under subsection A, if the person receives public sector workers' compensation under the DC code, he cannot also receive other remuneration from the district with certain exceptions. Under subsection A1, which took effect in 2010, if a person receives public sector workers' compensation under the DC code, he cannot receive disability benefits from the federal government for the same injury. Not only has Mr. Fant managed to check off both violations, but he has done so in the face of a scheme that is designed to make it difficult. When you apply for federal disability retirement, you certify that you understand you cannot receive both. When federal disability retirement benefits are granted to those already on district workers' compensation, benefits are paused. Claimants are understood to elect to receive one benefit only. And this is something that Mr. Fant acknowledges himself on page 387 of the agency record. He writes, "I am a retired disability annuitant who has elected to receive workers' compensation benefits in lieu of an annuity." For each subsection, I plan to focus on a couple of key points. First is subsection A, which concerns other remuneration from the district. Certainly, we don't dispute that the Civil Service Retirement Fund is administered by the Federal Office of Personnel Management. But that's a different question from where the salary, pay, or remuneration comes from.
So,
Go ahead.
well, so for sure, it's administered federally, but it's also a federal fund. The actual money in there is the property of the federal government, not of the district. Would you agree with that or disagree with that?
Well, as we read even the federal statute, the district is required to make matching contributions.
That's true, but my question is, once they make those contributions, is it still the district's property, or is the district make those contributions, and then who has, whose funds are those after the district makes those payments?
Our view is that to the extent that the statute talks about salary, pay, or remuneration.
My question isn't about the statute. My question is like a question of property law. If somebody said to the district, like, what are all the assets you own? Would they include the money that they had contributed, that they were required by law to contribute relating to Mr. Fant's employment? Or would they say, no, that they wouldn't list that as anything of this, district, that's not district property anymore. That's property that the district was required by law to send along to federal entities, which is then administered by federal funds. I'm just asking, like, who owns it, not what statutory terms yet. Who owns those funds once the district makes those payments?
I don't know that there's a clear answer to the ownership question, to the property question. I think there
It
is
seems, there may not be, but, so you don't know the answer to that question. You're not sure who owns it. You're not
not,
claiming,
not
you're
in,
claiming
not
you-
in terms of property law.
Yeah,
no.
and you're not claiming you own it.
Well, I suppose not. No, I mean, what we are claiming is that the way that salary pay remuneration work by definition is that they exist in connection with the services performed by an employee of the district government. It was-
I was just trying to, so again, you were acknowledging one feature that makes this more indirect rather than directly from the district. And one of them is that the funds are administered and the payments that come out are administered by the federal government. You acknowledge that's true. I
Yes.
got that. And I was wondering about other features that make it more indirect. And at some point, maybe you start wondering whether it's not indirectly from, but it just isn't from. And so I was trying to figure out who owns the money from which these payments are being made. And it sounds like you're not claiming you own them, but you don't know whether you do or don't.
I think that's about
Fair.
right. Yes.
And is it also true that the payments that are made are not equal, they are calculated in relation to, but are not equal to or limited to whatever payments were made in by the district? So whatever comes out of that fund as a result of federal disability retirement, it's not like you take the money that the district put in, and that's a fixed amount of money, and what comes out is equal to that. But rather, it's put into a big fund and that has lots of other contributions from other folks. And what comes out of it, if anything comes out of it, because there may never be disability retirement, so it's possible nothing will come out of it for all those contributions for Mr. Fant, it's possible none of them could ever come out. Some of them did come out, and the amount in which they come out is not equal to the amount that was put in, but instead is derived by a set of complicated statutory provisions that relate to, but are not exactly equivalent to the salary that Mr. Fant earned while he was working for Department of Corrections. Is that true?
That may very well be true.
You're not sure whether it's true.
I'm not certain whether it's true. Certainly contributions from the district are among the funds that are disseminated to claimants like Mr. Fant.
Understood.
It's our view, as a question of statutory construction, it's our view that one of the main reasons why this statute interprets those funds as deriving from the District of Columbia is that there's this exception at the end of A4. That exception makes it clear, first of all, that it's the district workers' comp that's imperiled if you collect double compensation. The other thing it makes clear is the subsection is read to impair the right of an employee to compensation for non-scheduled disabilities. So
I mean, I agree with your point in isolation that there's an implication from that provision that non-scheduled workers' comp would be disqualifying. I mean, I get that. My difficulty with that is that that's an inference from statutory structure that seems reasonable in isolation, but less so if you look at the other subsections of the provision. Because when I look at the other subsections of the provision, it seems to me that the statute was not written at all carefully to distinguish between the property of the federal government and the district. And so inferences I'm going to draw from this is a logical statute and here is the logical implication of it seem problematic. So like subsection 2 and subsection 3, can you explain to me the function of those, like the necessity for or function of those exceptions?
no, I'm not going to stand here and claim anything about the existence of a district navy, for example. I think both parties are equally sort of ill-served by these sort of leftover provisions. I don't think that the lack of clarity as to what they might do informs one case over the other. But I do think it's important to note that the reason why these leftover provisions appear to exist is that this is a federal statute that was adopted wholesale by the district. Under FECA, the system works more simply because the only system at play is that of the federal government. You can't collect additional remuneration from the government if you are collecting workers' comp under FECA. And so in adopting the statute, the council did essentially replace the numbers of the statutes and essentially replace the words United States with the word district. Now, in the federal system, the way around double compensation, as we argue here, is to elect the benefit that you wish to receive, which is what federal employees do under the CFR.
Right, but in the federal system, it makes more sense that the concern would be double compensation from the same entity or sovereign, right? I mean, that's the whole point, that when we transpose this into the DC context, that just comes right around to the question of whether this is actually remuneration from the district. Which, I mean, if it is, then you've got a double compensation problem. If you don't, then you don't have a double compensation problem, at least with respect to the same sovereign, right?
Sure. And that takes us back to what I think is our very best case for the law seeing this as remuneration of the district, which is that there's an exception that would seem to suggest that you're not allowed to do it unless you're receiving a schedule award.
Right. I guess I'm just saying that the fact that the federal government contemplates this with respect to FICA doesn't necessarily support your point, because that might reflect a concern about double compensation from the same entity, whereas you don't necessarily have the same concern if we don't see this as remuneration from the District of Columbia.
Well, entity is one way to look at it. Another way to look at it is sort of whether the same funds are being dispersed twice, which is to say the district's contributions. And which to me is sort of a more substantive way of conceiving of what double compensation really is.
And can I ask you, so I was interested in the word double compensation and what you think it means. For sure, if Mr. Fant were permitted, and he was for a fair while permitted, to recover both DC workers' comp and federal disability retirement. So there, in that sense, there were double payments in that there were two sources of payment. But the phrase double compensation or double payment seems to imply something worse than that, like it's duplicative or it's unfair, or it's unreasonable, or it's more than should be appropriate. And I never saw, I haven't seen an explanation in the district's brief, maybe you can provide one now, about more concretely, why is it somehow inappropriately double compensation, over compensation between above and beyond what would reasonably be warranted if one claimant can get both those forms of payment. It just didn't seem to me, I mean, it's surely double payment in one very simplistic sense of the term, but in the sense that you seem to be implying, it was not clear to me or explained yet whether it is or is not like offensively double compensation. For sure, you don't want someone, for example, it's a well-settled principle of workers' comp law that you're not going to allow somebody to end up at the end through the workers' compensation system of getting, more compensation, leave aside schedule award for minutes, but wage loss compensation. You're not going to let them get more than their salary. That's like undue excessive compensation. So there are principles that will say, no, don't interpret these provisions to provide unwarrantedly large compensation. But did I miss in your brief some explanation of why you think combining these two is unjust, unfair, overcompensation beyond what anyone should ever reasonably get in light of what happened?
Well, two sort of answers to that. I mean, the first one simply goes back to what I said to Judge Schenker, which is the idea that you are dispersing essentially monies from the same fund twice.
Why is it, and why is the same fund, the money that goes, I
shouldn't say fund, I should say monies from the district.
Yeah, but I mean, one of them is about workers' comp, one of them is, disability retirement. There were different payments made in different schemes. So it's not so obvious to me that allowing somebody to recover both is offensively double compensation. I get the point that the federal system doesn't permit it if you're inside the federal government. So it's not what the federal system intends for fully federal employees when it's all on the federal side. And so that suggests it's more than what the federal government wanted to provide for its folks. I get that. There are exceptions though. So if you're in the Army, apparently it's fine to get both. So it's just a little unclear to me that it's offensively excessive if we were to interpret these statutes to permit both to be recovered, that somehow that would be absurd or unreasonable. That was never established to me and isn't clear to me.
Sure. I mean, I don't know that with respect to offensiveness is the standard that we argue for or the standard that we need to meet.
No, I'm not saying that. It was just that there's this phrase you're using like, well, this is double compensation in a way that sounds pejorative. And it just isn't clear to me that it's double compensation in any way other than that it is compensation from two different sources that relate to the same topic and that may involve funds from the same employer. But that, so if you're trying to suggest that it's problematically double payment in some sense, some policy sense, it sounds like you're not trying to make that argument. Or if you, at least if you're trying to make that argument, I haven't yet got it.
Certainly the council was of the view, it appears to us when they passed subsection A1, that receiving compensation twice for the same injury would be inappropriate. And
Well,
based on the.
Maybe not inappropriate, again, I'm failing to see the policy argument, but they didn't want it. Right?
Right.
That's what A1 says.
Right.
Very clearly. And it seems so clear, and I prefer easy to hard. I'm sort of wondering, why is the district so interested in having us resolve this under A? Why can't we just go to A1?
I think the court absolutely can, and I don't think that we have a particular preference over one basis of decision as opposed to another. Our argument as to A1, well, let me, I would say at the outset that.
I mean, A1's not without its complications, right?
Sure.
But at least the text is more clear as far as what the council wanted.
The council said that A1 was meant to clarify the existing law's coverage of payments for disability benefits. That's why I'm inclined to read it not as a new rule, but a clarification of what they understood the law to already be. But yes, and I would note that certainly my friend does not dispute that A1 is read to ban the sort of benefits that his client received. The objection that we have from the other side here is one of retroactivity. The claim this is an impermissibly retroactive statute. Let me line up for the court a few of the reasons why we believe that this is not a retroactive statute in the first place, that it operates only prospectively. First of all, there's Altman, which we cite on page 27 of our brief. Altman says that the retroactivity question is not about vested rights, which is something Mr. Fant concedes in his brief on page 41. Landgraf observes that a prospective law banning gambling, for instance, will certainly harm the person who had already begun to construct a casino, receive the relevant permits, and so on. Here, the law would prevent new payments from being issued. In practice, it's actually even less restrictive than that, because the amendment was passed in 2010, and ORM only sought to stop payments starting in 2017 when it sought to cease Mr. Fant's benefit.
I mean, that seems, I realize your argument is that ORM is being generous in that respect, but it seems inconsistent with your position that it's prospective. I mean, it could have been prospective from 2010. So
That's exactly right.
I mean, why not take the consistent position then that you should be able to definitely not go back prior to 2010, but at least to 2010?
Yeah, that is our view, that ORM could go back to 2010 without sort of having to open up an analysis as to whether going back further would be impermissible.
But your ultimate position is you could claw back everything.
Well, I don't know. I mean, I'm comfortable taking a position that we could claw back to 2010. And there are provisions in the CMPA that have to do with recouping retroactive. Sure. But I mean,
So I get some of the points you're making about whether this has a retroactive effect, which is to me a somewhat murky inquiry. But the formulation of the test, and there are different formulations of it, which is part of what makes it murky. But one of the formulations that your opponent principally relies on is the idea that the 2010 statute created new legal consequences for events that had already occurred. Do you agree that it does that? And if you don't think it does, why do you think it doesn't?
I don't agree that it does that. And the first reason would be that these are temporary benefits that are at issue here. They're always subject to modification. If a claimant fails to keep the program apprised of his doctor's visits, or if his condition changes.
So if there were a statute that said, if you are injured, you're entitled to 8 weeks of some kind of compensation. That's temporary. It's not, very few things are permanent, right?
Sounds like a schedule award.
It does, but my point is that it is not temporally indefinite. And then imagine I'm injured, and then 2 weeks later, the legislature says, you know what, actually, you only get 4 weeks of compensation. So that would have been, there was a provision that temporarily compensated me for an injury. And after and told me I would get 8 weeks worth of compensation after that injury. And then after the injury, the legislation is passed that cuts that back to 4. It seems like that would create a new legal consequence. The old legal consequence was if you were injured, you get 8 weeks of compensation. The new legal consequence, and I'm injured, and then there's a new statute that says, oh yeah, you know what? The legal consequence is not what was said. The legal consequence instead is you get only 4 weeks. that would seem under that formulation of what is a retroactive effect, that would seem to be a retroactive effect under that formulation. That's not the only way of looking at it, so I can understand that that might not be dispositive, but do you disagree that in the hypothetical I just gave, although those are temporally limited benefits, a provision that after an injury decreased the amount of the duration of the temporary benefit would have a retroactive effect, and which is not fatal. It just means that there's a presumption against reading the statute that way, and then you get into a statutory interpretation question. But do you agree that would have a retroactive effect, or you don't think it does?
I think if it were after the award had been
You
granted.
don't think it's after the injury, you think it's after the award.
That's my instinct here. I mean, I think Your Honor is right that it can often be a close question. And you know, what I would point to for assistance is cases like those that we cite on pages 29 and 30. You have DirecTV, where the circuit rejects an argument that a new scheme for auctioning out satellite channels disrupted a previous order that had guaranteed certain networks a pro rata share of existing broadband. In cosmetology schools, also within the circuit, you have a federal law disrupting students' reliance on a student loan program by changing the rules on what constitutes an acceptable loan default rate for participant schools. The circuit there observes nowhere in the program participation agreement are member schools promised or even led to believe that there will be no background changes in the federal law governing the GSL program. And on top of that,
I mean, maybe these cases are analogous. I'm trying to figure out how one compares qualification for temporary disability benefits with contracts for loan agreements or whatever the case was that you were just discussing. But once again, if given the choice between doing something hard, doing something easy, I like doing something easy. And I'm wondering, why not just go the route of saying, okay, fine, there's a presumption that this is impermissibly retroactive. We can overcome that presumption, right? Or are you conceding that if there's the presumption, you're done, you're out, you lose?
right. Well, no, certainly I don't mean to concede that, but you know, I mean, the brief, because in our view, to us, this is a fairly square question of a prospective statute. You know,
But humor me.
sure.
How would you overcome the presumption?
Right.
Or are you saying that you can't?
I would note that by definition, we're dealing with an injury here, and this is not the sort of circumstance in which a person would have perhaps acted in reliance. There's case law that points to the fact that injured parties did not elect anything to become eligible for benefits that are later withdrawn. Certainly, we have cases like Atkins v. Parker, which point out that due process will not in any way hamstring municipalities from reducing existing entitlements.
That seems like I mean, I had not taken your opponent to be making a constitutional claim, and I assume you agree.
I agree.
So the question of whether you overcome any presumption against retroactive application, if retroactive application is found or assumed, is a statutory interpretation question, not so much a due process question. And I would think, in part, you'd look at the language of the provision. And do you think the language of the provision itself suggests anything about whether the legislature clearly intended to apply the 2010 enactment to folks who might already have been receiving benefits at that moment? I mean, there are other possible, people had awards, people receiving benefits, people had injuries, there are other possible benchmarks, but take Mr. Fant, who I guess had previously been employed, had a previous injury and had previously been receiving benefits. So all those benchmarks are kind of behind, earlier than 2010. So do you think the statutory language itself tells us what the legislature intended with respect to whether its enactment would apply to folks in that situation?
Certainly, the statute did not seek to grandfather anybody in. There's no language to that effect. The language speaks in terms of eligibility for compensation under the subchapter. To us, that points to being about the compensation, about receiving the payments. So that's sort of our textual argument as to a prospective reading.
And
of
it
the
says
statute avoiding
is
the case law.
receiving disability, not was awarded.
Yes. I mean, I would say that's exactly right, except that that's a reference to receiving funds from CSRS. And so the fact that both of those funds cannot be received contemporaneously.
No, but I think the suggestion is that by focusing on it seems to provide an effect to people focused on whether they are receiving benefits, and which is something that will be happening in the future for someone like Mr. Fant, rather than anyone who is injured or who is something that had already happened for Mr. Fant. So the thing that the legislature would cut off is tied to a thing that will be happening to Mr. Fant in the future, I think was the suggestion. Another question I have, I guess, is what do you make, if anything, of the fact that this reaches back to folks who were employed as long ago as it is focused on people who were employed by the district 23 years earlier. One, at least arguably, could think that suggests not a purely perspective in every possible way of that inquiry, but instead, folks who it's reaching back a long way in time.
Well, it's reaching back to it's reaching back to recipients of ongoing benefits who were employed by the district.
Well,
Sure.
although strictly speaking, I mean, it seems like if it's reaching back to people who have been working for the district for a long time. That is really all. It's not tied to benefits. It's how long you have been working for the district. Your injury could be in 2026 or whatever.
Right.
But it is reaching back to people who have been, longtime employees. So it has a backward looking focus to a degree, rather than sort of people who were hired by the district after time X, which would have more of a prospective kind of feel to it.
Well, I would say it's not looking back as to the action of the statute. It's looking back as to the class of people who are eligible for either this clarification or change, depending on how you view the statute. But to us, the clarification or the change is the key aspect, and that's consistent with Landgraf and Altman and the other cases that we cite as to subsection A1.
So I'm sorry, I've gotten a little confused, but
Sure.
are you resisting the suggestion that by statutory language can overcome the presumption against retroactivity? Are you maintaining an argument that this is a prospective statute as of 2010 forward?
Yes.
Okay.
I'm certainly, I believe that a handful of the arguments I've presented here are useful to the extent that we might overcome the presumption against retroactivity, but it is not our view that.
So that argument is not inconsistent with your
Right,
fallback would be.
Precisely. Sort of, I understand that this issue doesn't necessarily sound squarely in retroactivity, but something I just want to briefly address because it seems to be important to my friend's brief. Mr. Fant, the record shows, was undoubtedly aware that there was a rule against collecting double compensation. There was the letter that he wrote in March 2008 informing OPM that he was no longer in receipt of benefits from the district and that his retirement annuity should be activated. There's his acknowledgement that I mentioned earlier that he elected workers' compensation, and that acknowledgement appears in a letter where Mr. Fant expresses curiosity as to what he would receive from OPM if those benefits were to cease. In the end, to the extent that existing law, which is to say subsection A, may have left open the question of double compensation, the new subsection aimed to close that gap. We believe it should be allowed to do so. And unless there are further questions, I'm happy to stop there and come back in a few minutes.
Sorry, I just had
Yeah.
one quick question. What's your explanation? I mean, Mr. Fant dutifully reported to ORM that he was receiving these funds for every year on the year, right? From 2010 to 2017. And ORM did nothing.
I don't mean to suggest any dishonesty on the part of Mr.
No, but what's the explanation as to why this wasn't caught? If this was your position that the statute all along said what it said?
For one reason or another, the district dropped the ball in noticing that this double compensation was occurring. I would note, however, that Double compensation occurs so rarely, largely because it requires a pretty unique procedural posture for a claimant to be able to get there. Here, Mr. Fant appealed from the termination of his benefits. Since those benefits were terminated, he was able to go back to OPM and say, please reactivate my account. At the same time, he had litigation going as to an appeal from the termination, litigation wherein he ultimately prevailed and did not inform OPM, at least contemporaneously, that he had.
Right, thank you, Mr. Kennelly. Now we'll hear from your colleague.
Good morning, Your Honors. Harold Levy for intervener David Fant. It pleased the court. I've represented claimants in the public sector workers' compensation program for about 20 years. My experience of late suggests that this appeal by petitioners is part of a plan on the part of the Office of Risk Management to avoid, to reduce, or to wherever possible, eliminate benefits which the Comprehensive Merit Personnel Act requires the District of Columbia to pay to claimants. At the same time, it's been my experience that ORM is rewriting the CMPA wherever it can in order to affect the obligations of the Office of Risk Management in the District of Columbia under the Comprehensive Merit Personnel Act. Let me demonstrate this very briefly before I go on. Not long ago, I had the opportunity to represent Alma Atkins in a matter involving this court. It's cited at 281 A3rd 588, and it regarded an ORM rule which sought to change the burden of proof, take it off the shoulders of ORM and foist it on the claimants. Thanks to this court, the court ruled against the government and continued the burden of proof on claimants. ORM's appeal in this matter, petitioner's appeal, regards another termination of benefits. In that case, at the outset of this matter, ORM sought to impose a rule and a directive on David Fant to seek review by Office of Risk Management of its termination of his benefits back in 2017, as well as to go to the Superior Court on an appeal, if there were one, from Office of Risk Management.
Your counsel,
Superior Court.
sorry to cut you off, but your client, I know you didn't represent him at the time, but seemed to understand as of 1993, when OPM held his annuity in abeyance, that, and he didn't, as far as I know, complain about that at the time, that he seemed to understand that this was the scheme.
The confusion that existed at that time, and I was not representing him at that point, was the references to the program OWCP. That was an acronym, an abbreviation for the Office of Workers' Compensation Programs under the Department of Labor, not the DC Workers' Compensation Program. What he attempted to do at that time was to respond to the Department of Labor that he was not receiving OWCP benefits, because in fact, once he complied with DC law as a DC employee after home rule, he was receiving DC wage loss benefits for his injury. So I think the confusion that existed on his part going back then and how we represented to OWCP Department of Labor was as a result of the benefits that he was in fact receiving. In that, as I was indicating, the Superior Court ultimately, before this case ever came to OAH and the CRB for its final compensation order and its affirmation of the reversal of the termination, the OWCP, the Superior Court determined that based on the CMPA, the statute, that Superior Court did not have jurisdiction, which the Office of Risk Management alleged that it had. So this was a second instance in which the courts have determined that ORM overreached in its determinations by the adoption of its rules.
Well, I'm not sure that in those two instances, at least, the word overreach, if it has a pejorative connotation, is warranted. I mean, they took a position, the court ended up reaching a different conclusion. It's a strand of your argument in your brief that is to a degree kind of ad hominem, which is, the court has been critical of ORM in other cases, and you focus on Harrison and cases like that. But at least for me, it would help if instead of discussing like other matters and whether ORM succeeded or failed in those other matters, the merits of this case.
The instant appeal in this matter is about ORM's intent to rewrite section 1-623.16 of the CMPA. There was no hearing involved in this matter. This matter was received and determined based on stipulations of fact. The party stipulated that Fant was hired in 1976 before DC Home Rule. The party stipulated that Fant was injured in 1989 while working for the DC Department of Corrections.
So counsel, sorry, I'm gonna cut you off again, and we're familiar with the stipulations of fact. And I think we're just very interested in hearing about your interpretation of the law. And you've noted that ORM has sought to change the statute, and in fact, the statute has been amended, right, with A1. I don't know whether you want to start your argument with explaining why A1 doesn't preclude benefits for your client, or whether you want to start with A.
I would like to start with A. I think it's clear that the Comprehensive Merit Personnel Act provides that while a DC recipient of workers' compensation is receiving those benefits, he may not receive other benefits from the District of Columbia. Nowhere does that statute recite that he may not receive benefits from the federal government. The statute was, as counsel has indicated, was adopted from section 8116 of FECA, which provides exclusively that while a person is receiving federal workers' compensation benefits from the Department of Labor, he may not receive other federal benefits from the United States government, with exceptions that are irrelevant here. It doesn't provide that a federal workers' compensation claimant may not receive District of Columbia remuneration or District of Columbia benefits. When the City Council enacted the CMPA in 1977, it took the exact language of FECA of 8116 and only eliminated benefits from the federal government and replaced that with benefits from the remuneration from the District of Columbia government.
What do you make of the exception to the exception in A4, which says that generally, the last sentence of A4, which creates an exception to the exception that A4 created, it says eligibility for benefits under other retirement or disability systems for employees of the government. I'm not entirely sure which government, so I'm interested in whatever thoughts you might have on that. Does not impair the right of the employee for scheduled awards. And their opponent's argument is by carving that out, there's an implication from the legislature. The legislature must have meant to imply that non-scheduled awards would have been disqualifying. What's wrong with that line of thinking?
It's difficult to comprehend how all of a sudden council is able to bootstrap in federal benefits when that section only deals with 07 provisions for scheduled awards. I think they were clearly trying to indicate that scheduled awards, however inartfully, that scheduled awards could be duplicated. By saying that, they weren't trying to exclude anything else. They were just trying to make sure that there was no confusion that it would be permissible for a claimant to receive a scheduled
So
award.
that you think they would have thought, oh, it's fine if you're confused about unscheduled awards. We just want to make very clear that scheduled awards aren't problematic, but be confused as you like about unscheduled
Absolutely.
awards.
I don't think.
Unscheduled awards. That seems somewhat implausible. Why would they feel a need to be clear about scheduled awards, but have no concern about a lack of clarity relative to unscheduled awards?
I think one has to look at what the city council did in its wisdom when it adopted the statute, including those exceptions, which may not be considered relevant to, to the District of Columbia. It doesn't operate a Navy or an Air Force or an Army. But clearly they were trying to make sure that they left in the possibility for scheduled awards. As to A1, it's difficult, Your Honors, to fashion an argument that A1 does not apply retroactively, impermissibly and retroactively to David Fant.
Can I ask for
At
a
the
second?
time-
You say impermissibly. There's nothing impermissible generally about retroactive application. The Constitution sometimes steps in to preclude it, but I have not understood you to make a constitutional
No,
argument.
I
So I'm not-
apologize. I apologize as I misspoke, but what I'm trying to say is it's difficult for me to understand how the statute does not apply, as applied to David Fant, would not apply retroactively and in this regard impermissibly. At the time, the city council was enlisted by ORM to adopt A1 in 2010, and there's no doubt that risk management is the party that asked the city council to adopt A1. It clearly had the David Fant matter before it. There's no doubt. He had been receiving benefits.
You're saying that the
benefits
council's,
for 3 years at that point in time.
I'm sorry, that you're saying the council specifically considered your client's case?
It did not. It
Okay,
did not. If risk management wanted the city council to apply the law retroactively to David Fant, all risk management had to do is ask the city council to put in language that demonstrated clearly that it would apply to a claimant, no matter when he or she.
but maybe they thought the language that it contains now was clear enough.
Well, I mean, in our way of thinking, in our position, clearly it does not. It applies. It tries to bring in employees, which, as Your Honor said, were hired before 1987, in an attempt to construct around home rule, because these employees all had to be federal employees at one point in time before they became DC employees in order to be covered in any way by this change in the law. At the time, David Fant contributed or DC contributed money to US OPM on Fant's behalf. Fant had given up some benefits as a federal employee, some benefits that were protected by the home rule legislation.
Can I ask you, I'm sorry to shift the subject a little bit, but I understand in general terms your argument that the statute operates retroactively as to your client, but I'm not quite sure I know what your view is about how it operates prospectively. So what is the key that has to happen after the enactment of the statute? Is it the injury that is the source of one of the two forms of compensation, or the disability or injury that is the source of one of the two forms of compensation at issue? Is it the getting of one of the forms of compensation or the other? Or there are at least four things that seem like could be what you might think have to post date the effective date of the statute for the statute to be operating prospectively. And I don't really have an idea of how you think the statute permissibly operates. What has to happen after 2010 in order for the statute to be lawfully prospectively applied to someone?
I think what has to happen is that from the time that a new employee starts to receive.
When you say a new employee, you mean someone hired
Well,
in 2010?
employee, not a new employee, but an employee for the first time begins to receive those benefits.
Which
after the
benefits though? You
statute.
mean, which benefits? The workers' comp
The
benefits?
work- the
or
worker
the
comp
prior?
and or the federal benefits
or-
to preclude. I mean, at some point in time, there has to be an election if there wants to.
Yeah, I'm just trying to really make sure I understand what you think the trigger is for a legitimate prospective application. And I'm not quite sure yet, because there are two forms of compensation. One would be the workers' comp that the person is recovering or trying to cover from under the DC public sector workers' comp scheme. The other is federal disability retirement benefits. Which do both of those things happen? Which of those has to
No.
happen after 2010 or?
I don't think both have to. This is a DC law we're applying. So for a person to receive DC workers' compensation benefits, I think he has to have begun to receive the federal benefits after the law took effect. So the change in the law took effect so that there was there could be a settled expectation at that point that this new prohibition applied to him.
And your opponent argues in the alternative that even if this statute does operate retroactively to people in your client's position, that there's only a presumption against retroactive applicability and that the statute should be interpreted to overcome that presumption. What's wrong with the argument that even if this is a retroactive application of the statute, the statute by its terms or by its logic contemplates that, clearly contemplates that?
I don't believe that by its terms or by its logic, the statute applies in that fashion, but clearly to the extent.
What would help me is why you don't believe that.
I think one has to look at the facts as ORM understood them at the time that it asked the city council to adopt A1. Clearly, ORM, if not the city council, was plainly aware of the David Fant situation as well as the Mildred Carey situation, which initially came to the Court of Appeals on a petition for review after the CRB and OAH decided that case adversely to ORM, and then ORM, the petitioners, dropped that appeal. So the case was that case never was decided by the Court of Appeals, although it was initiated. But I think at the time the case first came, the city council first took up the consideration of the A1 change. It clearly had information available to ORM, which requested the change in the statute regarding both Mildred Carey and David Fant. And it did not make it clear that its intent by words in the statute was to apply that retroactively.
Why is it not?
It used the 87.
Why is it not clear enough when the statute says, the first part of it is you will not be eligible if certain things are true. And the thing that it says has to be true is that the person, is receiving, now is my word, so is receiving federal disability benefits. Why isn't that tell you, so going forward, no benefits under this, at least going forward, no benefits under this provision if the person now is, as of the moment of the enactment of the statute, is receiving disability benefits. If that's a retro application, then maybe, but nonetheless, the legislature seems to focus on, for the operative effect of the statute, what do you need to know? You need to know the person was, worked for the federal government of DC at least whatever it is, 23 years ago. And you need to know that the person, something is happening now. Why isn't that, if that's retroactive application, why isn't it what's contemplated by the statute?
But it's retroactive because at least
No, I understand it. I understand your argument that it's retroactive, and I'm assuming that it's true. The question is, why isn't it clear that the legislature nonetheless, here's what it says. It says, if these things are true, no benefits for people who are receiving. So that seems to clearly contemplate that no benefits starting on the date of the effective date of the statute if the person is now receiving benefits. What would they need to do to make it clear?
It would have been more appropriate for the court, for the city council to designate that those benefits would be inappropriate going forward, whether or not the person was clearly receiving the benefits at the time the law went into effect.
You mean whether, and that is true without regard to whether the person already has been receiving them, is what you think should have been added?
Yes, but applying Landgraf, I think the court was interested, and the city council should have been interested in the factual situation. I don't know if there's any other claimants that are in the boat that we're in as a result of A1. I don't know about Mildred Carey. other than David Fant at this point. If that statute was directly designated to deal with the David Fant situation, the ORM and the city council did not make it clear that it was the intent to apply that statute in that fashion against David Fant and against any other claimants who might come up under that statute in the future.
All right. Thank you, counsel. We
Thank you.
appreciate your time. Mr. Finelli, we'll give you just a few minutes.
Sure. I want to make just one brief point as to each subsection. And as to subsection A, if you'll permit me, another crack at Judge McLeese's question about sort of the policy interest in prohibiting what we're calling double compensation. If David Fant were receiving temporary disability benefits and were continuing district employment, and he would not be eligible for federal disability retirement. In that sense, there is a sort of double windfall that he would not, that policy reasons would counsel against him.
You mean, that sounds more like a disparate treatment kind of point, which is other similarly situated folks don't get this, so he shouldn't, or are you saying?
No, simply that it would be an inconsistent theory as to the reason that he's receiving benefits. If he were continuing to work for the district, he would not be eligible for. Oh, well, sure. No, actually, I mean, I suppose that can be interpreted as sort of like a policy argument as to making sure he doesn't receive a windfall that others don't. Sure.
But again, it's not so clear to me it's a windfall. I mean, objectively, the legislature could determine it's not compensation that wants to require the public fist to support, so I get that. But in terms of the words like windfall, I mean, if I am working for the district, if I'm a district employee and I'm injured and I had a high paying district position and now I can't really do that anymore and I can work for the district and I can get some money. I mean, I actually can get that because under A1 I can get in return for services actually provided.
That's right.
I just still not quite sure it's a windfall, but
okay.
So
I've done my very best on that one. But as to A1, and this goes more to Judge Easterly's questions. We certainly agree that we would, if we interpret this statute as being retroactive, we agree that we would certainly overcome the presumption against retroactivity for benefits going forward. And as Judge McLeese has pointed out, the statutory text of A1 seems pretty clear that it's about telling claimants who were previously eligible that they are no longer eligible for disability benefits. And that to us is, it seems to be exactly what A1 was pointed towards.
I know you had two objectives. I think you may have met them.
Yes.
There's something I wanted to ask about during the original argument. I
Sure.
omitted to do so I'm hoping I can do it now, which is just to address a point, a topic that was raised in passing by your opponent, which is about jurisdiction and what the right path of review is. The district's position up until its brief in this court, at least as far as I could tell, was that this case is on the wrong path. And that actually the CRB lacked jurisdiction to adjudicate this matter, and the right path was over in Superior Court. The district did not seek review of the Superior Court's contrary ruling, and in this court, the district has not argued that we're on the wrong path anymore. And I have two related questions about that. One is, what is the district's position now? Are we on the right path, or is this really the wrong path? That's question one.
It happens to be our view that we are on the wrong path, but we are constrained by our failure to appeal from the Superior Court decision denying its own jurisdiction. And the reason why, as I understand it, from consultation with colleagues, the reason why we didn't appeal from that Superior Court decision was other concerns about jurisdiction having to do with, I believe, the merits nature of the decision. Fine.
Fine. I don't really,
Okay.
I'm not sure, at least for my purposes, I just want to make sure I knew what your position was.
Sure.
Um,
And yes, so the extent to which that we could be said to have not prevailed on the merits, we weren't clear that we would actually be able to appeal.
it isn't obvious to me that you would have been foreclosed from your failure or decision not to appeal in the other matter would have foreclosed you from raising that here, but maybe that's right. I'm just not sure. My second question is, does the district have a position on the question of whether if the district is right, that this is the wrong path, whether that affects our jurisdiction in a way that means that we have to decide that question sua sponte, or whether the district's view is that that might have been the wrong path to get to the CRB, but that is not a topic that affects this court's jurisdiction in a way that makes that mandatory homework for us, even if the district chose not to engage on the topic in this court.
Yeah, our view on that is essentially the ship as to the non-jurisdictional argument has sailed. We don't believe that we're in a position to contest that.
Understood, but
Oh, but you're saying sua sponte.
my question is whether we have a sua sponte obligation to decide it because it goes to our jurisdiction, or whether instead you think that it doesn't go to our jurisdiction, and therefore that since you haven't pressed it, we don't have to decide it. If you have a position on that question.
Right. I can't give you an answer on that with complete certainty. Certainly, yeah.
I just want to make sure I understood.
Certainly, as I think I have made clear, we have no intention of advancing an argument that the court lacks jurisdiction here.
Fair enough, thank you.
I would simply note, as to subsection A1, our interpretation is the only one that gives meaning to that exception. We believe that, I'm sorry, that was subsection A. We believe that A1 meanwhile should be applied in the way that it was apparently written, and that the text is plain. So we're urging the court to reinstate the 2017 cessation of benefits on either basis.
Thank you, Mr. Femeli. Thank you, Mr. Levy. We appreciate your time, and this case will be submitted and court stands adjourned. Thank you.
All right.